E063 of 2025, Republic versus Michael Aballa. The orders of the ruling will also apply in E064 of 2025, Republic versus Michael Aballa. The ruling on 17th November 2025, Honorable Celeste Okore allowed the suspect's notice of motion dated 17th November 2025 in miscellaneous application number E1640 of 2025. Among the orders she issued was the requirement for the suspect to appear before the Ethics and Anti-Corruption Commission on 18th November 2025 to have his statement recorded. On 25th November 2025, parties appeared before me, and following lengthy submissions, this court respected my sister's orders by directing that the suspect do present himself to the EACC officers to record his statement and for processing as directed. The matter was then fixed for mention on 2nd December 2025 for further directions. When parties appeared before me on that day, that is on 2nd December 2025, the defense counsel confirmed from the bar that the suspect and his counsel indeed presented themselves at the EACC officers by the investigation officer and blatantly refused to record his statement as ordered by the court. He then went ahead to seek orders that the plea in this matter be deferred until such a time that the EACC will have complied with the orders of the court. He further prayed that the terms of the suspect's release of personal bond 500,000 be extended pending plea taking. The defense counsel also disclosed that the rest before the suspect hearing can take plea. In his response, Mr. Bore, the prosecution counsel, informed the court again from the bar that they complied with the orders of this court, in that they already amended the charge sheets as proposed by the defense, and that the suspect hearing was cautioned and processed. He further submitted that on 25th November 2025, there was new information that came out after delivered my ruling. The new information was that the suspect's statement had already been recorded. He submitted that since the orders did not specify whether or not he was to record a fresh statement, the investigating officers simply cautioned the process and cautioned and processed him by taking his fingerprints. He pointed out that the new information had not been brought to his attention at the time he was responding to the defense counsel's submissions on 25th November 2025. I would really consider the submissions by both sides. Right from the outset, I must emphasize that this court neither can nor should instruct an investigative agency on the manner in which to carry out its investigation. Such authority is granted to the Office of the Director of Public Prosecutions. This is a case where there is a charge sheet, and the prosecution wishes to have the suspect hearing and take a plea. If I comprehend their stance correctly, the investigations have concluded, which is the reason the charge sheets for both cases, of both files, were drafted and filed. However, the defense counsel has informed the court that he has written to the DPP and that in his letter, part of which he read out to this court, they have raised some issues, including issues which touch on the complaints they have raised before this court. Mr. Bure has acknowledged that indeed the said letter was received, but he needed time, at least a week, to seek directions from the DPP. Under Article 157 for the Constitution, the DPP can direct the Inspector General, and in this case, investigative agency, to investigate any information or allegation of criminal conduct, and the Inspector General shall comply with any such directions. Article 157(6) of the Constitution further lists the powers of the DPP, which are listed in, replicated in the ruling. Indeed, it is is accurate that Honorable Kore and this court directed that the suspect in this matter be afforded a chance to provide his statement. However, in light of the new information indicating that the relevant statement has already been recorded, it would be inappropriate for this court to require that the statement be recorded prior to the suspect taking plea. Given that the prosecution counsel requested additional time to obtain further directions from the DPP, I'll leave that office to determine whether it is essential for the suspect to provide a further statement, considering that the court has been informed that he has already recorded 2 statements previously. Regardless of the directions provided by the DPP, the question of whether the suspect's statement was indeed recorded, as this court was informed from the bar, will remain a matter for trial. Having said that, hereby will set this matter for plea taking before the duty court on a date that we are going to set shortly. The terms of the suspect's release, as set by Honorable Kore, shall however remain in force pending taking of the said plea. Those are the orders of the court.
Thank you, Your Honor. We must state from the onset that we are satisfied, especially the clarity that the court has brought insofar as the question of recording of the statement is concerned. The reading of the law by the court that this could be a trial issue is accepted, and we consider it as dispositive of that issue. We no longer want to pursue it beyond that level. Secondly, Your Honor, and I believe on the aspect of the ruling, we are all united, because I don't think prosecution counsel is agreed by the ruling. We also not agreed by the ruling. So insofar as the directions of the taking are concerned, Your Honor, I just have one more intervention. I pray that the court indulges on this. The charges belong to the DPP. Part of the prosecution is the work of the DPP. Under Article 157, Sub-Article 6, as read together with Sub-Article 10 and 11, the Director of Public Prosecutions has the authority to initiate, continue, and discontinue criminal charges against anyone at any time.
So that
the question of when the suspect can take plea, I just wanted to submit that we take directions on that. It would be better to take a mention date to confirm the status, because we could come back. The upshot is we could come back here on the date. These charges are under review, and the DPP could say, I have looked at it and I've decided to discontinue. There's a possibility in law. I would appeal to the court that we take a mention date to confirm progress. Then on that mention date, then we can now set a date for plea. Is that when the court sits where it sits, looking at counsel and the case person and all these other counsel, one of the things that we must not do as defense counsel is to lose favor with the court. Because then, once you lose favor, there's a lot of discretion the bench exercises. So we don't want the court to look at us and decide we're stubborn. Then as we agree on that date, is that the prosecution counsel does not take that date as not a set of plea-taking date, so there will be no need for review. Kindly proceed with the review, and when you come back, if the review is not successful.
We appreciate the ruling, and I already indicated yesterday, I only need 1 week to...
Yes, you said that you need
Yes, Your Honor, stated, I don't forgo the review process just because the plea date was set. Your Honor, we continue with the review, but we wanted to also take a plea taking dates before duty court. If the DPP gives any direction, we will inform the court on that day. That is all, Your Honor.
I give you a date before the trial court,
I think
so that you
I would
will bring it to closure before that court.
I would have thought we can mark it as closed now.
So, Mr. Aballa, you are for the applicant in this particular file.
I move the closure of that file now closed. The orders sought in that file having been spent in the same time.